Good afternoon, everybody. Thank you for attending our sessions here with today's fair housing. I just want to do a couple of reminders before we get started. Please keep your microphones and your videos off during today's presentation to help eliminate distraction. Also, if you need a certificate of completion, please email Stacy at the end of today's presentation and she will get that sent out to you. So welcome to anybody that is new to our landlord presentations. So with that, I will turn it over to Kirsten with fair housing.
Thank you. So my name is Kirsten Small, and I am an investigator with the North Dakota Department of Labor and Human Rights. I have been with the department for just over 9.5 years. I've done a lot of different kinds of investigations. I've done a lot of wage and hour investigations, a lot of discrimination investigations, including discrimination in housing. So a lot of what we're talking about today, I obviously have a little bit more in-depth knowledge about what on the legal side of things, what fair housing means and what some of these laws, kind of how they play out in reality when it comes to some of these complaints that we have. As I go through the presentation, if you guys have any questions, absolutely put them in the chat. We can certainly go through those kind of as we go along, but we'll absolutely have time at the end to go through any specific questions that you have. And I'll try to provide you guys some additional information and guidance on kind of where to find additional resources, additional information to help clarify kind of the very deep depths of what fair housing is. And there's a lot of information. I know it's 2-hour presentations can always be a little difficult to sit through for the entirety. So hopefully I will make it seem at least interesting and be able to give you guys some great information as far as how we look at any sort of fair housing issues and some of those common laws that we see it violated or have concerns with that come up. So first and foremost, we're going to talk a little bit about the department. I think it's easiest to know a little bit more about what we do as a department as a whole to get a better understanding of kind of when a complaint is filed with our department, what kind of timelines you're looking at, kind of what other issues that we deal with. We'll talk a little bit about what housing discrimination is. We'll talk kind of a little bit about the just normal kind of layman's terms definition of it, as well as the legal definition. We'll talk about what fair housing laws we handle and kind of what fair housing laws you should be aware of as far as any sort of violations of discrimination, kind of what those fall under. We'll talk about the statistics and facts as far as the kind of cases that we handle, kind of case resolutions. And then we'll also talk about and common issues, common complaints that we see that come through the department, as well as common questions that we have that come up. And then we'll talk a little bit about best practices going forward from here and what to expect if a complaint is filed, as well as what are some things that you can do to ensure hopefully that you don't have any sort of violations occur in the first place, but also if those violations occur, steps that you can take to make sure that you have the documentation needed to be able to present if there is a complaint filed. So the department itself, when I first started at the department, this is something that always kind of surprised me. I guess when I think of the Department of Labor, I always think of a much larger entity. The Department of Labor and Human Rights is actually an extremely small agency. We have currently on staff 6 full-time investigators. We have 1 temporary position investigator, and then we have a human rights director, a director of operations, an administrative assistant that kind of handles all the front end side of things for us, and then the labor commissioner. So when it comes to our actual staff, we honestly can fit at most people's dining room tables. We're a very small agency. I know, again, it's something that always caught me off guard because I guess I assumed it was always much larger. So when you call investigator frequently. So what do we do as a department? So obviously a lot of it's in the name, the Department of Labor and Human Rights, but we really have three main divisions as far as the department goes. We have the wage and hour division, and that contains all of our wage and hour laws. So things related to unpaid wages, any of the youth employment certificates or regulations as far as ensuring young employees are following the kind of work duties and hours that they are permitted to do when it comes to unpaid wages. So if an employee it believes that they have not been paid their full wages or unauthorized deductions have been made, all of those things fall under our wage and hour division. The Human Rights Division, that's going to pertain to our discrimination side of things. Discrimination and retaliation is all what falls under the Human Rights Division, and that is discrimination in employment, housing, public services, and public accommodations, as well as credit transactions. The last piece or last pillar that we handle is the education and awareness. Obviously, we do a lot of presentations such as this just to provide general information about the kind of laws that we handle and ways to prevent those. But we also have information on our website. We have informational brochures. We do various booths at various events. Like I said, we do presentations for all of the different areas that we handle. So the wage and hour side of things, as well as the discrimination side of things. So when it comes to our department, these are kind of the three main pillars or main areas that we look into. When it comes to the agency as a whole, initially we actually were part of the Department of Agriculture, but now it is kind of its own entity, and it is the labor commissioner, who is kind of the overseer of our department, is an individual that is appointed by the governor. And so currently our labor commissioner is Nathan Spajovic, and he is, I believe, our 13th labor commissioner that has been appointed by the governor. So when we talk about the Human Rights Division, and we'll go a lot more in depth in regards to this, but again, just kind of some general information of the main laws on that human rights or discrimination side that we handle. So the Human Rights Act, this is going to be more of the all-encompassing piece of the law that handles the discrimination in employment, in public service and public accommodation, and any retaliation laws. That's kind of what the Human Rights Act covers, all of those pieces of it. The one that we will obviously be talking about the most today is the North Dakota Housing Discrimination Act. And so that's the one you'll see come up frequently through our discussions today, but that's obviously pretty self-explanatory. It's housing discrimination, so discrimination in any sort of housing as far as rentals, sales, those type of things. We also have the bottom two are two retaliation laws that we have. The first one being the North Dakota whistleblower law. This pertains specifically to employees that have reported some sort of law violation or a rule violation, and as a result, they were retaliated against. So for example, let's say an employee refuses to perform some sort of action that they believe is in violation of DOT laws or regulations or OSHA laws. And as a result, the respondent took some sort of retaliatory action against them. That would fall under that North Dakota whistleblower. The last one is specifically for public employees. That's the North Dakota Public Employee Relations Act. This one we do not see quite as frequently because it is a very narrow scope that we're able to look into. Basically, if an employee of a state agency files a written complaint with an agency head or the Attorney General's office, and as a result, the respondent took some sort of retaliatory action against them, that would fall under that North Dakota Public Employee Relations Act. So again, really brief overview, just so you have a better understanding of what it is that we handle. So the wage and hour, this is the piece that we see by far the most when it comes to complaints. So it's always worth mentioning because of that reason, that really when it comes to the kind of majority of cases we get, the majority of phone calls we get, they much more frequently pertain to the wage and hour side rather than the discrimination side. And that can be for anything related to wages. So it's unpaid wages, wages for work performed, hours of work issues, again, those youth employment, so those 14 and 15-year-old or under 18-year-old regulations that limit what kind of duties employees can perform. We do independent contractor verifications. So we do have authority over employee employer relationships, but we do not have any authority over an independent contractor. So if an independent contractor believes that they have been unpaid wages, they are unable to file with us, but we do have the ability to make that determination on whether or not what that relationship is truly an employee employer or if it is an independent contractor relationship. We also handle provisions related to sub-minimum wage or employees that are being paid less than the minimum wage. And then we also have provisions for employment agency licensing. Like I said, these are kind of the complaints we see the most frequently. And a lot of times it's because, it's pertaining to wages. It's something much more black and white as far as if they believe they have not been paid properly or unauthorized deductions have been made improperly or they have not been paid out their vacation wages upon separation. It's a little more black and white to have this evidence showing I believe I'm entitled or owed this and this is a reason why. So we see a lot of wage and hour complaints filed. In the last biennium, the 2021 through 2023 biennium, we had 722 cases filed and 492 cases closed. When it's in the nearly 10 years I've been at the department, you absolutely see the ebbs and flows of complaints. Obviously, I began shortly before the oil boom started. And so I got to see kind of the influx of what occurred with the oil boom and all of the complaints that came in with that. Likewise, when it comes to additional maybe employers coming into the state or kind of various different aspects of work coming into the state, we just see ebbs and flows when it comes to complaints. So some years we certainly have more closures than openings, and other years we have more openings than closures. As far as the human rights side of things, again, this is definitely the smaller piece of what we see, but when it comes to that human rights side, it's really the discrimination. We're talking about employment discrimination, public service, and public accommodation, which means a public service would be, for example, the city water department or the police department, that they're providing some sort of service to the community. And if an individual believes that they have been discriminated against in the receipt of those services, then they can file with our office. Same with the public accommodations. It's somewhat of a similar situation. What it is if the employee, let's say, goes into a business or a restaurant and they believe that they were discriminated against in the services that they received, then they can file a complaint with our office as well. So that's what those public service and public accommodation discrimination cases are. Credit transactions. This one kind of bleeds over occasionally into the housing discrimination as well, because this is discrimination in some sort of housing or some sort of credit transaction. So it could be for a mortgage, it could be for a car loan, it could be for a personal loan, it could be anything that's related to some sort of credit transaction, and they believe that they've been discriminated against based on during that interaction. And so based on that, they could file a complaint with our office. And then lastly, housing discrimination. Again, this is the one that we're going to go into the most depth about, so I'm not going to really go too far into it right now. Of these complaints, by far, we see the most coming from the employment discrimination when it comes to those human rights. And really, it's a lot of employees believing that they've been discriminated against by their employer, by the workplace that they're in, whether it's some sort of harassment based on a protected category or requesting reasonable accommodations, or they believe that they were discharged in a discriminatory fashion. All of those may fall under that employment discrimination, but employment discrimination is the issue that we by far see the most frequently filed on. So as I stated before, we had a little over 700 cases filed for the wage and hour. As you can see, the human rights side of things is much smaller case amount. We have 432 cases filed in the last biennium and 333 of those closed. Of that 432 total, we had 308 employment cases that were filed, 52 housing cases that were filed, and then 16 public service and public accommodation, as well as 56 complaint of retaliation or that whistleblower law complaints. So as I said, you could tell just from the numbers, 308 of those being employment discrimination. That is obviously, substantially heavier than all of the other areas. So we do see the most with employment discrimination, and then housing would follow usually shortly thereafter. So what exactly is housing discrimination? Obviously, discrimination is one of those words that easily can be interpreted or evaluated by different people and have different meaning to different people. There's the dictionary definition, there's the legal definition. So we're going to kind of walk through all of those different discrimination definitions. But when it comes to what housing discrimination is, it's treating someone differently in the sale or rental of housing because of a person's membership in a protected category. So this is obviously, again, somewhat of a broad definition. We'll give you a lot more insight as to what this means. But basically, it's meaning that you are treating someone differently or behaving differently towards them in any sort of housing transaction because of the membership in a protected category. Sometimes when it comes to these situations, it's not that it's always individuals are kind of blatantly discriminating against someone or they're intentionally discriminating against someone. Sometimes some of the complaints that we see may not have had ill intentions and they may actually have had good intentions, but whatever the action was resulted in a discriminatory action. So when it comes to housing discrimination, there are fair housing laws that are enacted to basically combat any sort of housing discrimination. We have the Fair Housing Act of 1968. This is going to be the federal side of things. So this is the federal law. There's a lot of guidance on it on HUD's website. It's enforced by HUD. And then there's the state law, which is that North Dakota Housing Discrimination Act of 1990. When it comes to both of these laws, they are what we call substantially equivalent. So we have a partnership with HUD where we can investigate cases for them and they can investigate cases for us. Basically, one of the benefits of that is that instead of having two separate investigations, a federal investigation and a state investigation, or two separate complaints, it's a way for a complaint to be filed under both the state and the federal law and be able to be investigated all at one time. But with that partnership, we do have to have our laws, again, be substantially equivalent or very similar to what the federal law is. We can't have any laws that contradict what the federal law would state and vice versa. Basically, it's our laws can go above and beyond, but we can't have any laws that would eliminate protections under the federal law, and the federal law wouldn't have any provisions that would limit the ability for the state to have, again, kind of above and beyond those provisions. So obviously those are the two fair housing laws that we handle, but what do the fair housing laws do? Again, those laws make it unlawful to treat someone differently in the sale or rental because of that person's membership in a protected category. So when it comes to the fair housing laws, again, they're in place to combat any of that discrimination. And so it's basically trying to level the playing field and allow anyone to have the same equal access and enjoyments of a property, regardless of their membership in a protected category. So we talk a lot about this word protected category. So what exactly does that mean? It doesn't mean that you can, that you're tied to ensuring everyone's treated differently, regardless of any sort of prospective category. It's only these limited categories that a case can be filed under in our laws. So the protected categories on the Fair Housing Act, or the federal side of things, is color, race, familial status, which would mean basically for parents, either children of under the age of 18 living with the parents or legal custodians, pregnant women, and people securing custody of children under the age of 18. National origin, color, religion, disability, and sex. So those are the federal categories that are protected categories. So basically, these categories mean that any sort of landlord or housing situation cannot discriminate against somebody because they reside in one of these categories. So they can't discriminate against someone because of their color or because of their disability. And so that's what it means when we keep talking about that protected categories. As I said before, the federal and the state law are substantially equivalent, but the state law can go slightly above and beyond when it comes to any sort of protections. So we handle and cover all of the main categories, the same ones that the federal law covers: color, race, familial status, religion, national origin, disability, and sex. But we also have additional protections that are what we call state only protections, which means that they're not protections under the federal law, but they are protections that are in our laws and at various stages. Some of these laws are relatively new as far as protected categories, but others have been enacted years and years ago. But when it comes to those state protected categories, we have domestic violence, and this is for individuals that are basically protected under some state program. They're victims of domestic violence and that they are participating in some sort of state program related to that domestic violence. We have marital status. This could be many different forms of marital status. So it could be that you believe you're being discriminated against because you are divorced, or it may be because you are single, unmarried, or it may be because you are married or widowed. So that's what the marital status piece is. We have public assistance. This is the receipt of public assistance. So that because you are receiving some form of public assistance, North Dakota rent help, it may be that you're receiving Section 8 vouchers, that you're receiving some form of public assistance. And as a result of you receiving that form of public assistance, the respondent has discriminated against you. And then lastly is age. And this is a protected category that's actually on the federal side for employment discrimination, but for housing discrimination, it is not, but it is covered under our state law. And what the age category it is, it doesn't mean that you're being discriminated against based on any age. It only has coverage for individuals that are age 40 and over. So that's when it comes to age, it's only for individuals that are age 40 and over. So when we look at an individual, when they file a complaint, or when we're looking at a respondent, we're looking at, is the aggrieved person a member of a protected category? As you may expect, based on what those protected categories are, most people fall in some kind of protected category. We do have, when we have a complaint that's filed, we do look at, is there a nexus or a connection between the alleged action and the individual's protected category? When we look at that, especially in that initial intake stage, or kind of those first steps of, we have somebody who's coming to us with allegations of discrimination, we obviously, again, we really clearly try to define what that nexus or that connection is. But in some situations, an individual may not have the evidence or information that would outright demonstrate what that connection is between whatever the action was. So maybe the eviction or the non-renewal notice and their protected category. So sometimes it can be looked at somewhat broadly, but we do request that there's some sort of nexus or connection in why they believe they're being treated differently based on their membership in a protected category. We also look is the dwelling or the housing related transaction covered under the law? So is it a rental, a sale? Is there some other form? Is it related to housing? Did they reside there or did they have some sort of housing situation going on? And then we also look at initially up front, is the respondent covered under the law? So there are some various pieces that we're evaluating and we're determining, are they exempt? So that leads us to, are there exemptions from these laws? So are there exemptions from the North Dakota Housing Discrimination Act and the Fair Housing Act? Yes. The long and short of it is yes, there are a few exemptions from the law, which means that basically these laws may not have the same kind of coverage for all entities if they fall under one of these exemptions. These exemptions are very limiting, and there is going to be an assessment of it. It's not just we take their word for it and believe, oh, they said they're exempt under this, they must be. We do request documentation and information to support that determination. But when we look at those exemptions, there are certain sales or rentals exempt. It's also often known as the Mrs. Murphy exemption. And what that means is that is for a 4 or fewer rental units and the owner lives in one of those units. So if there are 4 or fewer rental units as a whole and the owner lives in one of them. I think one of the easiest examples, if you think of a fourplex and the owner resides in one of those units, then that would possibly fall under that Mrs. Murphy's exemption. Again, we do look for documentation and information about this. So it's not just that, yep, our manager lives in the building, so we must be exempt. It truly has to be the owner has to reside in one of those units. And so we do look up property tax lookups, various information about who owns the property. And so that true owner would have to be one of the individuals that resides in the unit, not just, let's say, well, the property manager, he resides in the unit and he does all of the managing of the property. Well, if he's not the true owner, it wouldn't fall under that exemption. There are certain religious organizations that are exempt as well. So religious exemptions, obviously, they can limit it to individuals of being only a certain religion or certain aspects. But religious exemptions, one of the kind of nuances is regardless of their exemption from those fair housing laws, they still cannot base their membership or limit their membership based on race, color, or national origin. So there are some limitations. It's not just kind of an exemption from all aspects of the law, but it does basically allow for some of the exemptions to the law, such as discrimination based on religion. Private clubs can be exempt, so a kind of a members only type of thing, somewhere where there is a private club, there's restrictions, but the private club, just like the religious organizations, it cannot restrict the membership based on the race, color, or national origin. So again, they may be able to exempt people from being allowed in on the property or residing in one of the units based on other aspects, but not on those race, color, or national origin. And then lastly, housing for the elderly. There are obviously some exemptions that may exist for elderly housing as it relates to familial status or age for developments that meet the certain requirements that are set for the housing for older persons. Again, this is one of those ones where if the respondent is claiming an exemption, it's something that we would look at as whether or not it qualifies under all of those aspects. So we'll talk a little bit about the statistics and facts. So talking a little bit about what kind of cases do we see? What kind of resolutions do we see with some of these cases? So for the last biennium, which again is a 2-year period, we had 46 total claims. This was down about 10 from the previous biennium. I have not run the numbers to date yet, but I know we're pretty much kind of on par for how we have been as far as housing claims. So I don't see a substantial increase or decrease in the next biennium. But as a whole, we had those 46 claims filed in that 2-year period. We had, of those claims, we had 19 of them that were resolved through what we call conciliation. And we'll go a lot more in depth about what conciliation is as we go through this presentation. But conciliation as a whole is finding some sort of resolution between the parties prior to the completion of investigation. So it may be that the parties maybe they decide to end the lease, or maybe it's that they decided to agree on some sort of monetary resolution, or maybe they just decided to grant the reasonable accommodation that was being requested. We have what we call conciliation offers that can go back and forth. So again, those informal resolution or settlement offers that would go back and forth between the parties. And if those discussions are successful, then again, the case would be closed as conciliated. So we had 19 of those the last biennium. 13 were no reasonable cause, which means that we believe a violation of the law did not occur. 4 are reasonable cause. And so that means that 4 of the cases that we had in that biennium were no reasonable cause, or we do not believe a violation of the law occurred. As you can see, this was up significantly from the last biennium, as we had 0 that were reasonable cause in the last biennium, but it doesn't necessarily, it's not, again, a sign of a frequent pattern or anything of the sort. It just can be that really every situation is very different, and sometimes a violation of law can occur based on one aspect, and you could have several cases at one time just happen to be. It's not frequent that we have definite patterns or certain kind of, I guess, waves of certain types of cases that come in that are frequently cause violations. It really is a case by case basis. 4 of the cases we had were dismissed, and it could be dismissed for various reasons. Oftentimes, if we lose contact with the complainant, or maybe it's being pursued through court already, there might be various reasons as to why we would dismiss a complaint. Again, because we have that partnership with HUD, means we can investigate cases for them, they can investigate cases for us, and as a result, we do have what we call referring the cases to HUD. So we can refer cases to HUD for them to investigate. And if we do that, HUD also can request to have cases transferred to them, or complainants can certainly request that HUD evaluates or does the investigation as opposed to our department. But we didn't have any of those in the last biennium. We did have a handful of cases, 6 total cases, 4 of which were withdrawn with resolution and 2 that were withdrawn without resolution. These are somewhat similar to that conciliation, but it could be very informal. It may be that once the complaint was filed, the respondent reached out to the complainant and tried to remedy the situation informally without us being a party to it. That may be a withdrawn with resolution. Sometimes we have individuals who have filed and then they've decided either as they go through the process, they don't want to continue forth, or maybe they have personal things that have come up, or maybe they've moved to a different unit and they just don't want to have to kind of relive or go through that entirety of the process. Then they can absolutely request to have their case withdrawn, and we would close the complaint. They still may have legal options as far as pursuing the issue through court, but our department would close the complaint if they request us to do so. So again, of all of those cases, so the 46 cases, kind of broken down by the type of protected category that these cases were filed on. So we had 28 that were filed on disability, 9 based on retaliation. So this would be that because of them opposing some sort of discriminatory practice, or requesting a reasonable accommodation. As a result, they were retaliated against by the respondent. That's what could be examples of retaliation. We had 10 that were filed on public assistance, that receipt of public assistance for various aspects. Again, it could be Section 8 vouchers, it could be North Dakota rent help, it could be some sort of food stamps, it can be related to their receipt of public assistance. 2 were filed on familial status. 1 was filed on national